The appeal, Joseph Croft, and administrator of the estate of William Horsford, deceased, against Geoffrey Croft.
May it please your lordships, I appear on behalf of the appellant, Mr. Geoffrey Croft. Mr. Geoffrey Croft is seated behind me, and my learned friend, Mr. Justin L. Simon, appears on behalf of the respondent, Mr. Horsford. Mr. Horsford is seated directly behind Mr. Simon. Before I begin my submissions, there are two matters of housekeeping and one update. So far as the matters of housekeeping are concerned, your lordships will note that Mr. Simon, in his written case, refers to an earlier matter, and that's the case of it's 0559 of 2008. Mr. Simon managed to locate the original judgment by Mr. Justice Mitchell, and you also have the Court of Appeal decision, which I provided. The next matter of housekeeping...
And the Court of Appeal over... We have that judgment we were supplied with
yes.
Over the weekend. Yeah.
And the Court of Appeal overturned.
Sorry?
The Court of Appeal overturned that first instance
and
decision.
The Court of Appeal decision has been provided, Lord, yes. And also, page 55 of the bundle, there's that important letter of the 19th of June, which is illegible, and I apologise for that, but another copy has been provided to the board, which is legible.
Thank you.
So far as the update is concerned, your lordships would have noted the judgment of Madam Justice Robertson in the case of Mr. Horsford against the Attorney General and Mr. Geoffrey Croft. That's number 641 of 2012. That reached the Court of Appeal. The Court of Appeal struck the appeal out because Mr. Horsford hadn't served the notice of appeal on Mr. Croft. Also, he didn't serve it. He served it late on the Attorney General, and the Court of Appeal held that in any event, in exercising its discretion, that appeal had no merit. So that struck out. So there is no further challenge to the decision of Madam Justice Robertson. So that was the update.
Thank you. And the date of that? The date of the Court of Appeal strike that?
Struck out, yes.
Date?
That was on the 26th of April.
Thank you.
My lords, this is quite an unusual case for three reasons. Because of the age of the parties concerned, both are 89 years old, the length of the legal quarrel, which stretches over some 16 years, and the number of actions that it's given rise to. But the central issue between the parties is the use of a road known as Parcel 281. And my lords, there is a plan which will assist before I go into the facts. And that plan is at page 614 of the electronic bundle. And my lord, on the plan, it can be seen that there are roads indicated in blue, red, and green. The road coloured in red is Parcel 281, also known as the Upper Road or Upper Eastern Road.
218, I've lost it.
281.
281.
That's in red.
No, sorry, the
614.
614, thank you.
And then the land in the road in blue is a government road that leads to the area known as the public highway known as Cobb's Cross. The landing green is the lower western road, and your lordships will see that the lower western road merges with the upper road. Towards the bottom of the map on the left-hand side, there's Bailey's Supermarket, and east of Bailey's Supermarket is the path that leads to the lower western road at parcel 193.
So where does that footpath run? It runs up
so it runs along, my lord. If one goes to parcel 193, and one goes to parcel 260, 219, 22, 223, 225, 226, 227, 228 and 9, and you'll see that then the road leads down to the blue road. So it goes to my right and then goes down to the blue road. So that's the path, the passage to parcel.
So that's it's a footpath running to the western side of 260, 219, 222.
Yes.
223,
yes.
And then it seems to hit a road at the bottom of 228.
That's correct.
Is that right?
That's correct.
So it's a road up to 229 from the public highway up to 229 and 228, and then a footpath.
Yes, my lord.
Up until you get to the green.
Yes.
Lower western road.
Yes.
Okay. Thank you.
You say there's a footpath. I mean, who owns the footpath?
It's not owned by Mr. Horsford.
No.
One can see on there's parcel 209. That's the main parcel, but it was subdivided into parcel 302 and 303. So and then
I'm sorry, where are you now?
we're back to parcel 193, and if one looks to the left of parcel 193, at the top there by 1521 sees parcel 209. That was the parent parcel. That's been subdivided into 301, 302, 303. But 302 and 303 are not owned by Mr. Horsford.
Yeah, but who owns the footpath you've been describing?
It's unclear who owns the footpath, but it is not Mr. Horsford.
And it's not a. I mean, what sort of?
It's not a government road either.
It's not.
It's privately owned.
So there's no access from the lower western road down to the public highway.
Save for the footpath.
Save for a footpath, and that's a private road.
That's a private road, yes.
And it's a footpath.
Well, I say it's a footpath. It's probably better described as a dirt track, a narrow dirt track.
A narrow dirt track.
And this is all not disputed.
That's not disputed.
Yes, it is disputed.
Oh.
My apologies, it is disputed. Because we maintain that it is not a footpath, it's a public road. It's a road, not a public road.
Well,
Sorry, you.
And if I take the lordship to page 630 of the electronic bundle, which follows the respondent's submissions,
Yes.
you will see there is a map or plan which indicates the road on the left. We say it's not a footpath, it's a road and it leads down to the public road.
Do you say it's privately
I
owned?
have actually travelled on it.
Do you say it's privately owned or publicly owned?
It's privately owned.
Privately owned.
Yes, because it's not a government road. But it's a road which is used by all parties.
And when you say a road, is it metalled? I mean, what's the state of it?
It's a good road. It's not concreted. It's an open road. I've traveled on it, and so did one of the judges, Justice Cottle.
Right, but is it metal? Does it have tarmac on it, or is it?
No, it doesn't have tarmac on it.
Okay.
Yes. Yes.
So it is a dirt.
It's
a dirt track for these purposes.
Well, you could say it's a dirt. Well, I wouldn't say it's a track because the road, the vehicles do pass on it. But it's dirt because it's only really the public roads that you will find that they're metal and with the covering on them. And that would be government roads. When I say public roads, this is not a public road. It's actually a road of access which is given so that the parcels of land along that way have access.
I don't want to take up more of your opponent's time because he's opening the appeal, but in due course it would be helpful for both sides to give us references to relevant findings of fact or agreement on the facts to clarify this particular issue.
Very relevant.
And well, going back to page to my map, 614, I have. Yes. It's useful to look at the occupants of that road. I'm sorry, I'm just going to go back to my map again. I do apologise. One will see at the top of parcel, at the top of the red road, one sees 291 and 292,
Yes.
which was formerly parcel 217, and that's Mr. Croft's home there.
So I'm so sorry, before we move away from your plan, I had understood you to be saying that there was a footpath running down the from the bottom of the green.
Yes, I would describe it as a footpath rather than a road.
Right, but you described it as running down the western side of 223, 225, 226, is that right?
Yes.
Because I think the plan that we were shown at page 630 seems to show something running down the eastern side.
Yes. Can I say that in all the 6 years that I've been involved with Mr. Croft, I've never seen that plan before. It certainly wasn't before the High Court or the Court of Appeal.
All right. But in all events, you're saying that there's a footpath running down the western side of those plots that I've mentioned. Okay. And you'll assist us with the references to the evidence and
yes, I will do.
And findings of fact on that. Okay.
And going back then, my lord, if I may, I pointed out parcel 291 and 292.
Yes.
Next door to that is parcel 218. That is the land of Mr. and Mrs. Bridge, who feature in the evidence. They haven't built yet, but when I go to the evidence, the board will note that so far as parcel 218 is concerned, parcel 218 is allowed to use the upper road, and parcels 291, 292 and 218 were formerly parcel 171.
Sorry, can you give those numbers again?
Yes. 291 and 292 and 218 were previously parcel 171.
Thank you.
Yes.
But you see that later on, when we come to the judgment of Madam Justice Robertson, that Mr. Horsford said that 218 was not permitted to use the lower road, but could only use the upper eastern road. And then next door to that is parcel 154. and there is a house on 154. And then on the same side, on the opposite side, there should be parcel 143. That's right next to the Blue Road. That was the home of Mr. Van Beek and Joanna Tobbett. And now there are two houses there, one occupied by Joanna Tobbett and the other occupied by her daughter Shane Van Beek. They are entitled to use the upper road. Then going further down to the beginning of parcel 281 is parcel 100. Parcel 100 is entitled to use the upper road. And I should have added at the back. There's a parcel 216, which is next to the arrow, which points up parcel 281. 216, there's a house there, also entitled to use the upper road. And there's also at parcel 419, that is, which is underneath parcel, the arrow that points to parcel 281 on Upper Eastern Road. There's, above the word upper, there is parcel 419, which also uses the Upper Eastern Road. And so...
Not sure how that will get access to the Upper Eastern Road.
Yeah, so there is only one person who is not entitled to use parcel 281, and that is Mr. Horsford. Sorry, Mr. Croft.
So are there, on parcels 254,
Yes.
253, 126 and 104, which are contiguous along the western side of the upper road, are there houses or dwellings?
There are no houses there.
No houses.
There is only one house, which is at parcel, next to parcel 152, to the left of the Green Road. One can see parcel 230. That is the only property that uses the lower western road.
230.
Yes.
230. Yes. And
When you say entitled to use, that means potentially they've come to some agreement with Mr. Horsford, does
well,
it?
when we go to look at the evidence, you will see that Mr. Horsford contends that, save for parcel 216, which is Mr. Mullins, who occupies that when they purchased their land, he says the price included access to the land. That's the way he puts it. And in respect of parcel 216, he says there was, which was also purchased from Mr. Horsford, he says that there was an agreement in existence, a written agreement between Mr. Mullins and Mr. Horsford, which allows Mr. Mullins to have access to his home, but that agreement has never been disclosed.
And is it said by Mr. Horsford that entitlement to use the entitlement of plot 218 to use the upper road came about in that way as well?
No, my lord. one will see from the judgment of Madam Justice Robertson that Mr. Horsford decided that they were not allowed to use the lower road. And if one looks at the...
But my question relates to the use of the upper road.
Yes.
We were told that there's no house yet on 218, you said?
No house on 218.
But Mr. and Mrs. Bridge bought 218.
Yes.
And is it common ground that they have the use of the upper road?
There's a finding of fact by Madam Justice Robertson that Mr. Horsford sent a fact saying they were not allowed to use the lower road, they were only entitled to use the upper road. And we'll see that when we come to the judgment of Madam Justice Robertson, although...
And my question then is, on what basis is it said that they have the right to use the upper road? Is it because that right was included in the purchase?
Well, my lord, I would say that when it came to the sale of parcel 171, when one looks at the preceding correspondence and the correspondence afterwards, it was quite clear that when the land was transferred to Paul Van Beek, that there was an agreement that both the upper and lower roads could be used.
I understand that's your submission. My question at the moment is, on what basis does Mr. Horsford accept that Mr. and Mrs. Bridge are able to use the upper road?
My lord, I can't answer that question because I'd have to peer into the mind of Mr. Horsford. But Mr. Horsford made it clear as a condition of allowing the subdivision and of transferring to Paul Van Beek that the Bridges could only use the upper eastern road. So that was a condition prior to the transfer to Paul Van Beek.
Thank you.
Well, no documents were disclosed surrounding the transfer to the Bridges in relation to 218, but what we do have is a fact which I'll take you to later on, which is recorded in the judgment of Madam Justice Robertson. So one sees that all of these persons are entitled, all of the houses are entitled to use parcel 281, apart from Mr. Croft, and that even the Bridges, who occupy a part of what was formerly parcel 171, also are entitled to use the parcel 281. I'd like to go to the map again, just to look at parcels 291, 292 and parcel 218 again. The board will notice that parcel 291 and 292 is narrow at the lower road and wider at the top. And in relation to parcel 218, parcel 218 is wider at the lower road and narrower on the upper road, because what was envisaged by Mr. Van Beek was that he would divide the plot, one house would be at the bottom and one house would be at the top. And I'll go through the documents on that. So I think, unless there are any further questions about the map, that's all I propose to say about the map. Oh, one more.
But no house has been built on 218, and
yes.
And in any event, vehicular and foot access to 218 is on the upper road only.
Yes.
Yes, thank you.
Yes. And the appellant's problem stems from the fact that when parcel 171 was subdivided by Mr. Horsford, was subdivided by Mr. Horsford. It was originally parcel 26, but when it was subdivided, on his plan, he showed access to the parcel via a road at the top and a road at the bottom, the upper and the lower road. But he did not advise the relevant authorities that it was a private road.
That the Lower Western Road is a private road.
No, that both roads,
Both were private.
both roads are private roads, yes. Both belong to the estate of Joseph William Horsford, deceased.
When you say it was subdivided by Mr. Horsford in a way that showed access to the parcel from both roads, I mean, was there some document that did that?
I'll go to the evidence on that. There's no document that shows that, but that was dealt with in the evidence, and he accepts, Mr. Horsford accepts that he did not notify the authorities that both roads were private roads.
Right, but it was the way you put it. You said that when it was subdivided, it showed access to the parcel from both roads. That suggests there was a document that showed that.
No, there's not a document that shows that in the papers, although I think in the other case, in 0559 of 2008, a plan was actually submitted in that case.
Could you give us the date, please, for these divisions as you go through?
The division was on the 22nd of October, 1992.
Yeah, I don't. Is this right? Forgive me. 171 was.
171 was parcel. Originally, 171 was divided into parcel. Sorry, 171 was originally part of parcel 26. The whole of the land was one large parcel.
I think you may be talking about when parcel 26 was subdivided, aren't you?
Yes, when parcel 26 was
what you said to us was that when parcel 171 was subdivided.
Oh, I do apologise, yes. So when parcel 26 was subdivided.
So it's when parcel 26 was subdivided.
And parcel 171.
And that was on the 22nd of October, which year?
1992.
1992. And on Mr. Horsfield's plan, he showed access on both the upper and the lower road.
Both the upper road and the lower road, and there's no dispute about that, my lord.
So parcel 26 was subdivided into a lot of different parcels?
A lot of different parcels, yes. But in 1992, he created parcel 171, which was put into his name. So he owned that.
So can I just, in 1992, you've got parcel 26, which includes a lot of the parcels we see on the plan. Was it just subdivided so as to create 171, or did it create a lot of other parcels?
Just subdivided so as to create parcel 171.
Thank you.
And did 171 include all the land surrounded by the upper and lower roads?
No, parcel 171 was, as shown on the map, was a discrete parcel in itself of, I believe, 30,000 square feet.
Which is equivalent, is this right, to what we've got as 292,218?
Yes, because it starts off then in 1992, 171 is created.
Yes.
I'm with you.
171 is purportedly then sold to Joanna Tobbit, but never transferred. And we'll see that later on in 2005, Mr. Horsford, it's then mutated into parcels 217 and 218, then transferred to Paul Van Beek, and then later on down the road, Mr. Croft subdivides the parcel because, as well as building a house, he builds a cottage.
So in 1992, is this right? Parcel 171 is carved out of parcel 26, which is some bigger area.
Yes.
And that's when Mr. Horsford arranges as administrator of the estate to transfer 171 to himself in his personal capacity.
That's it, that's correct.
And is that transfer registered?
That transfer was registered, yes.
And does that registration show the access points to 171?
No, it does not show the access points at all. There is nothing registered in the encumbrances section. There is no right-of-way registered either along the lower road or the upper road. And of course, both the upper road and the lower road are the property of the estate.
Do we have in the record the whatever was shown in the register as far as parcel 171 is concerned at that stage? I've not seen it, but
No, I don't. There may have been a closed one, but which I'll try and locate later on in the parcels. But the pages are very.
So, well, are you able to help me on this? Was parcel 26, how was the proprietor or the registered owner of parcel 26?
The estate, my lord.
It
the
said
estate of
the
Joseph
estate.
William Horsford, yes.
The estate of Williams Horsford, right, okay.
Of which the respondent is the sole administrator.
Yes. And then obviously parcel 171 was registered in the name of Mr. Horsford.
Personally, yes.
Thank you.
And that was the 22nd of October 92.
22nd of October 1992.
Can I just ask you this as well? I mean, in this case, we've of course got the agreement for sale from Mr. Horsford personally to Miss Tobbit. And then there is some sort of document which transfers the legal title and is registered.
Yes.
What I don't think I've seen in the record.
There was never a we should have a...
You know, what I don't worry about this case, but in a typical case, A agrees to sell property to B, there's a written contract, and then subsequently it's the legal title, upon completion of the contract normally, is transferred from A to B, and that is what is registered.
Yes.
What document transfers the title? We've got the agreement, but what in old-fashioned terms was the conveyance?
It's called an instrument of transfer.
An instrument of transfer. I don't think we've got any of those in the bundle.
We've got one in relation to Paul Van Beek, but we don't have one in relation to Joanna Tobbit because the land was never...
No.
She bought it, it was never
Okay. Do you have the reference to that?
Yes, I'll get that now.
It's just trying to understand what the legal documentation
Yes,
is.
yes. It's in the... No. Sorry? You put the page number? No, it's in the bundle. I get the...
Well, don't worry now.
Yeah.
Maybe a chance later on.
I don't think the instrument of transfer is in the record.
It was in the record because what happened in the Court of Appeal, there was an attempt to reopen the case, and the parties actually put the instrument of transfer in, which Mr. Horsford claimed was a forgery. But in the decision...
But I do have the document if you need.
Yes, but we'll get that later. But it is in the bundle.
Okay.
And what then appears on the register? Does the register append the instrument of transfer?
No, it doesn't at all.
The registrar or whoever copies out the effect of that, is that
Yes.
right?
But what would usually happen is if there is a right of way, the right of way would be referred to on the register. And if there is a restriction, the restriction would be referred to in the encumbrances section of the register.
And when you say a restriction, is that the, in effect, the servient tenement recognising the right over it? That's
Yes.
what you're meaning by a
That's
restriction.
precisely. But in this case, no reference was made to rights of way or restrictions whatsoever in this case.
No.
And
But presumably, an instrument of transfer, if things were being done comprehensively and correctly, would also refer to rights of way.
Yes, it would do. It
Yes.
would do. But not, unfortunately not in this case.
Well, and never in a case of an easement of necessity. Because necessarily, you have if you've got an express easement, you don't need an easement of necessity.
Yes, precisely.
Yeah.
The point is, and one will see when we get to the evidence, the point is that Mr. Horsford saw this as being very much his own road, and he could do what he liked. He could charge people if he wanted to. He could stop people if he wanted to. We see that from the evidence. He sees it as being a privilege for the homeowners to get to their homes, and that's one of the difficulties. And I think that may have been due to his age and his understanding, but that's the way things went with Mr. Horsford.
Mr. Carey, can I just ask you this? When 171 was registered in the name of Mr. Horsford in October of 1992, was there any right of access to the roads recorded then?
No.
And similarly, was there an instrument of transfer in respect of that?
No instrument of transfer was disclosed, but at the same time, it's always been his case that it belonged to the estate, and it was up to the estate to do what they wanted. And in his evidence also, he would also say that access to parcel 171 was always historically from the lower road. And when we get onto the evidence, we'll see that can't be right, because Mr. Croft's house is built on a hill where there is a gradient in 1 in 2, and it slopes from east to west. And so we say you can't actually get up to his house from the lower road. You can't build a driveway, and also you can't walk up there. It's simply too steep.
Well, that is what the judge at first instance found as a fact,
Yes,
and he had visited the site.
Yes, and in paragraph 14 of his judgment, on page 15, he actually says that when he grants the declaration, so it's an unusual place to put it, but when he granted the declaration at page 15, is it page 15?
Could you give us the electronic file number, please?
Yes, it's page 15, paragraph 4. He says, a declaration is granted that the first defendant is entitled to a right-of-way as a matter of necessity of the claimant's land parcel 281, as there is in fact no other access to the property of the first defendant. And what is unusual about this case is that the Court of Appeal paid attention to paragraph 10 of the judgment, where the judge had said, that the trial judge had said that it was once patent that the access point in the Western Road was only apparent but far from real, and said that it was extremely difficult to build a driveway. And the Court of Appeal dwelt on that paragraph, but there's no paragraph of there's nothing in the judgment that deals with what the judge found as a fact at paragraph 14 on page 50. It's not mentioned at all in the Court of Appeal judgment.
Can I just ask you one other factual thing? Paragraph 10 of the judge's judgment talks about, at the entrance of this road, the claimant has constructed a gate.
Yeah.
Where on the map is that gate?
The gate is towards the entrance of parcel 19. One sees the green road at parcel 193, and it's towards the entrance of parcel 193.
So, in effect, at the end of that lower
Yes.
part of the green road, is that?
Yes,
right?
and if you're going to use the lower road, it's actually at the beginning of the lower road.
Right. But in any event, as I understand, well, are you saying that the judge found as a fact that even if you can get through the gate, you can't in fact get access
You
up
can't in fact get access to the...
to 292.
Yes.
292 or 291? 292.
291 and 292, that's formerly parcel 217.
Yes, you can't get access to all of that land from
No, you can't.
irrespective of how
Well,
it's now
I
been
think what he
divided.
was saying is you can't get to the house. It's impossible to get to the house. So if you drive along the lower road and you're at the bottom of parcel 291 and 292, you still can't get up the top to the house because it's built on the top of a hill.
Well, actually, he actually says in paragraph 10 that it's extremely difficult to build a driveway from this road onto the first defendant's property. I mean, not even up to the house,
Yes,
but onto the first defendant's property.
Yes. And that's because looking at the bottom of parcel 291 and 292, the distance is approximately 45 feet, but because it's so steep, it's difficult to create an S-bend so you can go around the top, and it's so steep that a car can't go up it. And we'll see that later on again, because when the Court of Appeal were dealing with final leave to the board, they accepted a report from a civil engineer, Mr. Sandy Mayer, who pointed out that it was impossible to get to his home. And for Mr. Croft, it's obviously of great importance because of his age, his deafness, his medical condition. He needs a carer, and he can't have a carer unless they can have access along the upper road. And even because it's a private road, even the emergency services, hospitals, ambulance, police, again, no access for them either. So it's really difficult for him. And what he really wants to do is he wants to come back home now. He's had enough after 16 years of litigation. He wants to come back home, but he can't rent or sell his house. He is stuck in Antigua until the question of this road has been resolved.
Now, can I ask, why is October 1992 not the critical date in terms of identifying whether there is an easement of necessity? Because that's the point at which 171 is carved out from lot 26, and so falls into separate ownership for the first time.
Yes, it would be critical, save for the fact that Mr. Horsford, in his evidence, says even when he created it, as far as he was concerned, access was from the lower road.
Or from either, and that from the lower road one could get down to the public highway, presumably.
Yes. But the difficulty is that when you look at the pre-contractual correspondence, it starts off on the 11th of October 2010 with Mr. Van Beek sending a fax through his solicitors to Mr. Horsford saying, I would like you to make an offer, but the offer is contingent upon opening up the whole site, that's the lower road as well as the upper road, and if the lower road is not repaired, then I only want to buy the top half. So it's quite clear.
You'll come to that, but in terms of the position in 1992, your submission to us is that access to this plot 171 was effectively only from the upper eastern road.
From the top part of parcel 171, the access was only via the upper eastern road.
And so far as we're concerned with the lower part, the lower part of it, it would be perhaps from the lower western road, but only via the upper eastern road, because you'd go around the top. Is that what it comes to?
Well, my lord, there was no evidence. There was no evidence to say that. I think Mr. Horsford's case was for over 70 years that parcel has been accessed from the lower western road. But the difficulty with that analysis is it's difficult to see how in 1992 a surveyor could have produced an accurate plan without travelling up the Upper Eastern Road. And indeed, by 2000, it's clear from the evidence that the Lower Western Road was in a state of disrepair, and one couldn't access parcel 171 from the Lower Road. And even in 2002, when Mrs. Tobbett signed the sales agreement, again, the position was the same, because you still couldn't access parcel 171 from the Lower Road because it was totally overgrown.
Can I just be clear as to when you say the easement of necessity, which I believe you're relying on?
Yes.
When do you say that started?
Well, I say that must have started in 1992. Because that's when parcel 171 was carved out. But in any event, I would also submit that it's quite apparent in 2002 as an implied easement as opposed to an easement by necessity, by the pre-contractual correspondence.
When you say
With Van
pre-contract...
Beek.
Sorry?
Oh, sorry.
Well, I was asking the same question. When you say pre-contractual correspondence, between whom and whom?
That's between Paul Van Beek and Mr. Horsford.
And that was for sale of which plot to Mr. Van Beek?
That would have been parcel 171.
So the whole of 171.
The whole of 171, and of course, it must be remembered that at that time, Mr. Van Beek died on the 17th of March 2009, but when he was negotiating with Horsford, he also lived at parcel 143 with Joanna Tobbett, so he had a right to use the road anyway.
Well, only in relation to 143.
Yes, in relation to 143, but it would be very odd if he couldn't visit his neighbour at parcel 154.
But insofar as there wasn't an easement of necessity in 1992, would you say in any event there was an easement of necessity in 2002, apart from your additional point that there's an implied easement from the pre-contractual correspondence?
Yes, and that's because it is impossible to get to the top, and as the judge found as a fact at paragraph 14 of his judgment, there is no way to access the parcel.
Because it might be said, mightn't it, unless I'm misunderstanding something, that back in 1992, we're talking about the administrator of an estate and that same person in his personal capacity.
Yes.
And it might be said, well, there's an arrangement, an obvious arrangement between the two. It's the same person, effectively. So at that point, perhaps arguing about an easement of necessity might seem rather odd.
I would submit that it's not odd, because there is no documentation whatsoever with the administrator reserving a right to himself to use either road. If there was a transfer where that was specified, one could say, well, no easement of necessity, but nothing was specified.
I mean, I wonder whether it doesn't get harder to get to an easement of necessity in 2002, because presumably the negotiations between Mr. Van Beek and Mr. Horsford are with Mr. Horsford in his personal capacity. No?
No, because
right.
at all times Mr. Horsford is wearing two hats. He's the administrator.
But he's not wearing two hats when he's selling 171. He owns it personally.
Yes, except that access must be provided to the parcel.
But he's the administrator.
Yeah.
I mean, isn't my lord right that really the moment when an easement of necessity most obviously would arise is in 1992, because prior to the transfer in 1992, you've got one common owner, namely the estate.
Yes, yes.
The estate sells 171 to Mr. Horsford, who happens at that time to be the administrator. In order to make that sale effective, because it's landlocked, the estate must grant a right of access, a right of way.
My lord, yes.
So it's a grant, not a reservation. That's
Yes,
important.
It's a grant, yes.
It's a grant.
Yeah. And there is...
Because, I mean, Mr. Horsford might cease to be the administrator the following day. I mean,
Yeah.
I mean, happily it hasn't happened, but he might become incapacitated or
Yes.
something of that sort. That was my lord. Seems to me is probably right there, isn't he? I mean, it's not impossible to possibly to find an easement of necessity in 2002, but one's got to jump through more hoops, I would have thought.
Yes, yes. No, I do concede that the first stage would be to look at 1992, and if there's an easement of necessity in 1992, then that easement of necessity subsists through to the sale to Joanna Tobbett and the eventual transfer to Mr. Paul Van Beek. So there's a transfer there's a sale to Joanna Tobbett in 2002, but no transfer. Then there is a transfer to Paul Van Beek in 2005. And
so, in fact, when we were just talking about 2002, actually isn't 2005 the relevant date, because in 2002 there's no transfer at all.
No, it's in 2005.
There's just a contract.
And this is where I raised in my written case the issue of an implied easement, and that's where the correspondence comes in.
But
there's no doubt.
Can I just be clear about this? I mean, as a matter of law, is the easement of necessity, does it arise at the time of contract or at the time of the transfer of the legal estate?
It must be at the time of the transfer of the legal estate.
Okay.
Thus far, I'm not sure there's that much between you, because, as I understand it, the respondent says that there was an easement over the Lower Eastern Road.
Yes.
And the upper Eastern Road was never the subject of an easement in relation to this particular plot of land, even before its subdivision, because access was always through the Lower Western Road and thence to the public highway.
Yes.
Have I understood that correctly?
Yes, that was the respondent's case. It was always via the Lower Western Road.
Yes.
Yes.
So there is a sort of big divide between the parties as to whether it's the lower road
Or the upper road, and the other side my loan relies on the eastern road because of the contract of sale making provision for the landlord for the repair of the western road. Yes, sorry. So in the sales contract, in clause 7, there's a provision saying that
So we're back in 2002 now. This is the sale agreement between Mr. Horsford and Mr.
Yes.
Tobbett.
But what we don't know is what were the terms between Mr. Horsford and Paul Van Beek, because of course Mr. Horsford always denied transferring to Paul Van Beek.
But, sorry, I had assumed that the transfer to Paul Van Beek was completion of the contract made in 2002 with Joanna Tobbit, because that contract provides for a transfer of the estate to Ms. Tobbit or her nominee.
Yes.
And I had assumed that Mr. Van Beek was her nominee for this purpose.
Was the
There's no evidence of any other agreement for the transfer, is there?
Well, no, there isn't. But when looking at the evidence of a whole, because
I mean, are you suggesting? I don't think this can really be open to, can it? I mean, I thought it was agreed that Mr. Horsford was paid the price under the contract with Miss Tobbit.
My Lord, it is agreed.
I mean,
yes.
So the transfer must have been pursuant to this contract, unless you're saying that this contract was rescinded, in which case presumably the purchase price was repaid to Mr. Horsford and was replaced by a new agreement to which effect was given by the transfer to Mr. Van Beek. But the difficulty with all that is that there's absolutely no evidence of it.
No, but there are certain findings that so far as the transfer to Paul Van Beek is concerned, that there were discussions between Mr. Van Beek and Mr. Horsford about the transfer, and that's the judgment of Madam Justice Robertson.
But how do they bear on this issue of the easement of necessity? Do they touch on it at all?
They don't touch on easement by necessity. They do touch on implied easement. And implied easement is my fallback position if I'm
I know it is, but the trouble with that is it wasn't pleaded. It wasn't pleaded as an implied easement, nor was it argued before the judge at first instance in this case, was it?
No.
Certainly he makes no findings about it.
No, but there was material before the judge upon which he could have made the findings because he had the pre-contractual correspondence.
But he didn't make them.
No.
So, I mean, it wasn't on the pleadings part of your case that there was an implied easement.
No, I accept that, but I also say it's a pure point of law which the board can deal with on the basis of the evidence before it.
Well,
So, Lord,
well, can that be right? And one would think that implication depends crucially upon detailed findings of fact.
yes. In Mr. Horsford's closing submissions, he did actually raise the issue of common intention of the parties. And so it was, as it were, before the trial judge.
My difficulty at the moment with your submission, and I'd be grateful for your assistance on it, is paragraph 19 of the Court of Appeal's judgment.
Yes.
Because in paragraph 19 of the Court of Appeal's judgment, after a reference to... I beg your pardon. It's, I'm looking at it actually in the... 326, I'm grateful. Looking at it in the other bundle. Page 326, paragraph 19.
I apologise. Yes, I have that here, 326, yes.
Paragraph 19 of the Court of Appeal's judgment.
And that's a paragraph where the Court of Appeals said that the transfer was to Joanna Tobbit, I believe.
It's about access to parcel 171 from the public road through the Lower Western Road, and that, as I understood it, was really a substantial point of difference between the parties.
Yes.
And leaving aside your point about the steep gradient within the parcel itself, the Court of Appeal here, having considered the evidence, appears to reach the conclusion that the access was in fact via the Lower Western Road.
Yes, except when the Court of Appeal looked at Clause 7 of the sale agreement, if I can get that up, Clause 7 of the sale agreement, that should be at 46 or 47. They read that as being the only access to the site, and that was quite wrong, because if one looks at the clause itself, what the clause actually says is that he will repair the road. It doesn't say that it's the exclusive access to the site.
Well, not so much even exclusive access. It was the way it was in fact accessed.
Yes, but there was the only evidence about that access came from Mr. Horsford, and if one looks at Clause 7 on page 49.
But is this anything to do with the clause? Because this appears to be an analysis of the of what happened in fact. There was in fact access to the public road from the Lower Western Road, and that, as I understand it, is that remains their case, and that any difficulty created by dividing 171 up into parcels 291 and 292 is not a difficulty of Mr. Horsford's making. That's, I understand it, is their case that you have to meet.
Well,
and the analysis of the Court of Appeal.
Well, my Lord, so far as access to, I know in the respondent's case and in the Form 3, what the respondent contends is that parcel 191 and 192 was actually landlocked because of the subdivision, but that cannot be right in fact, because when one looks at the map,
291 and 292.
yes, 291 and 292, one looks at the map again, one sees that there is some 45 feet along the Lower Western Road relating to parcels 291 and 292. And so it's difficult to see how it can be said that Mr. Croft's home is landlocked by reason of the subdivision, because the gradient remains the same in relation to parcel 218. The gradient is no different.
With respect, is that inviting us to make findings on the evidence which are not open to us without hearing?
My Lord, no, because I would submit that if one looks at the evidence, when one looks at the evidence and the correspondence in particular from Paul Van Beek on the 11th of October 2010, it makes clear that if there's no access from the bottom road, he will only purchase the top part, and that top part is via the Upper Eastern Road. And so I would say and there was no evidence at all in the court below to suggest that parcel 217, 191, 192 was landlocked by parcel 218. There's no evidence whatsoever about that. It was raised in closing submissions only, but it was never put. It was never put to Mr. Croft, and it was never stated in evidence by Mr. Horsford.
Yeah. The Court of Appeal, paragraph 19, have a footnote to the witness statement of Mr. Horsford, paragraph 7 and 8. Can you give us the bundle reference for that? So that we can just.
Is that,
Because the Court of Appeal seemed to have accepted that part of his evidence.
yes. His witness statement comes at page 65. And 7 and 8 starts at page 66. It says, first of all, paragraph 6, access to and from parcel was along a path leading the original point of entry where parcel 26 abuts the public road west of the glebe land. And then in paragraph 7, in 1993, parcel was transferred registration. I used the path mentioned in paragraph 5 above.
I think that's a slip for 6, isn't it?
Yes, as an easement to and from the public road, even though I may at times use other unconventional means. And at paragraph 8, he talks about the transfer to himself, and then talks about what the access was.
And when he refers to the glebe land, can you help us on the plan where that is?
I'm not sure where the glebe land was, because it's not indicated on the map, but...
Maybe there's some assistance, respectively.
Yes.
The glebe land would be parcel 131. Look at the bottom, just the front above the public highway, that triangular piece of land.
Yeah.
That's what's referred to as the glebe land.
Just so I can understand the case that's being put against you, could you please just explain to me how one would get from the Lower Western Road, how your understanding of the respondent's case,
My
as to how you would get
understanding
from the Lower Western Road
Yes.
via the glebe land to the public highway?
Yes. I'm going back to the page 614. My understanding is one sees Bailey's supermarket.
Yes.
One travels, there's a road from Bailey's supermarket that goes past 248, 247, 250, parcel 18. One then travels left and travels via 228, 229, then past 227, 226, until one gets to parcel 219, and then one sees the road, and then one turns right into parcel 193.
Yes. Yeah.
But it's certainly, and that is west of the glebe land, because Mr. Simon indicates the glebe land is 131. You look at the directions which are
Yes. Thank
given
you.
on the map. West is towards the left.
But your account is west of the glebe land, but also west of 228, 227, 226.
Yes.
That's what you told us.
And it makes sense, my lord, because if one looks at 193, one has to travel 302, 303, and down to parcels 203, between parcels 203, 228, and then down to the main road.
Do we know when all these parcels, 228, 227, 226 and so on, when they were all created?
They were certainly created prior to 1992.
Prior to?
Prior to 1992.
And who owned them in 1992?
Well, I'm not sure whether they were actually owned by the estate. Can I take some instructions from Mr. Croft? I'm going to have to show him on my map. I do apologise. I'm told by Mr. Croft that's a private estate, so it wasn't owned by.
Which one? Which was the private estate? Which one?
No. All of this is private land.
So it's the whole of it: 291, 220, 221, 222, 223, 224, 256. Sorry, 225, 228, 227, 228, 229. It's a private estate fenced off.
It's
nothing to do with the estate of Joseph William Horsford, deceased.
So it was. You say it's a private estate.
Yes.
Not owned.
Not owned.
At any rate, in 1992.
Yes.
By the Horsford estate.
Yes.
Mind you, we've got no evidence apart from what you're from either side about this.
No evidence from either side, but
see, it's quite. I mean, what I find baffling about the Court of Appeal's paragraph 19 is they say in the second paragraph, second sentence, that the evidence is that in 1993, Mr. Horsford used as access to the public road a path west of the Gleeland. You've described to us what that path was. And then goes on to say, so that parcel 171 enjoyed a right-of-way over the lower or western road. Well, I can follow that so far as the road marked green is concerned.
yes.
But I simply don't. It seems to me a complete non sequitur as far as the path, whatever it was, going from the end of the green road to the blue road. Because that was, if that was owned by other people, whether or not he used it, he may well have been technically trespassing when he used it, but it certainly doesn't mean that parcel 171 enjoyed a right of way over not only the green road, but all the way down to the public road. So at the moment, I don't really understand the basis of the Court of Appeal's conclusion.
No, and it's unfortunate that Mr. Justice Cottle did not make a finding of fact in relation to the land of strangers, but he didn't. But the
He didn't. Well, we don't know how it was put to him. We don't know whether it was put to him that there was a right of way.
It was put to him in evidence by Mr. Croft that one would have to cross the land of strangers.
No, what I mean is, was it put to him by Mr. Horsford that there was a right of way over all that land right the way down to the public road?
Wasn't mentioned by Mr. Horsford that there was a right of way.
Certainly, if that part of the Court of Appeal's reasoning falls away, then it may be said then there is indeed only one way of accessing these
Yes.
lots, which is nothing to do with the slope in a sense. It's because the only access is via parcel 281 and the Upper Eastern Road.
Yes, that's correct, my lord. And it's. I find difficulty with the Court of Appeal's judgment generally, because when one looks at the transcript, it seemed to have been, rather than a discussion about the evidence that had gone before the judge, it seemed to be a discussion between counsel and Mr. Horsford in the Court of Appeal about maps, and they were simply looking at maps and talking, rather than concentrating on what was the evidence below.
Then it becomes a very short point, doesn't it, which is whether there was ever any access, right of access to these parcels other than via the Upper Eastern Road.
Mr. Croft has just given me a note, so could I read that and then maybe take instructions? Yes. He confirms what I said. He says that the dirt track runs along the side of parcel 17.
Sorry, we're 17.
Parcel 17.
Oh, I see. Yes. Yes.
The big one on the left-hand side of
I.e. to the west of 227, 226,
Yes.
which is what you have consistently
Yes,
described to
yes,
us.
yes.
Just one further observation. If the Court of Appeal's reasoning about some right of access, as opposed to just a physical path, but a legal right of access down to the public highway from the end of the Green Road is flawed, then, I mean, it might be said that Clause 7 in the agreement with Joanna Tobbett is consistent with there being a right of access over parcel 281, because that would just be a question of, and if I drive round the upper eastern road and get into the lower western road, I want access from that side of the plot as well, but it would still, on this view of the facts, necessarily involve having access over plot 281 to get to the lower part.
Yes, it would. It would, precisely.
Well, that may be a fairly pivotal point between you then, because if there were a right of access from the public road to this plot along the lower western road, then it would make a very material difference to the ability to make use of this plot of land.
Yes, yes. It would be. It would be. I would concede that. But I think the difficulty is, my lord, is that when one looks at there are two things. There's the slope which the judge was concerned with, and there's also the access which the judge was concerned with, and also, of course, on the inspection by the judge, Mr. Horsford told the judge, and the judge records this in the judgment, that Mr. Croft would first have to have permission to use the lower road before he would be entitled to use it. And that's a point made strongly by the judge in his judgment as well. So, on the one hand, Mr. Horsford was saying you can't use the upper road, but then he was saying you can't use the lower road unless you have my permission. And then, of course, there was the gate there that Mr. Horsford was entitled to lock at any time.
Well, I mean, there'd be a question mark as to whether he was entitled to, if truly the right of way was over that lower road and thence down to the public highway, he wouldn't have the right to lock it. He might claim, well, I'm going to lock it, but he wouldn't have the right to do so.
The point I make is, throughout, Mr. Horsford has never ever given Mr. Croft permission to use the lower road, and that's been the position throughout. And that's recognised in the judge's judgment when Mr. Horsford tells the judge at the inspection that before Mr. Croft can use the lower road, he would first have to be given permission. And but in relation to paragraph 19, my lord, of the Court of Appeal's judgment, I'm not sure that the Court of Appeal were entitled to make that finding of fact. And in my submission, it seems to have arisen because of an analysis of the maps that were presented to the court, rather than looking at the evidence as a whole. Because the the reference to west of the Glebe land points to a different road altogether. And I'm not sure how one would get from, well, one would have to go over either 223, 224, to get to parcel 17 and parcel 303, but that's certainly not the evidence in the court below. And
well, the path you've described, the road or path you've described running from the main road does run to the west of the Glebe land.
it does run to the west of the Glebe land, but
before it then turns west.
yes, but the point I'm making is one enters on the road that I've indicated. So past parcel 17, sorry, past parcel 18, turning at parcel 18, going up to parcel 17. And then the question is, who owns that land? Because it's certainly not owned by the estate. So that would involve the Court of Appeal making a finding also that there was a right-of-way along parcel 17 to parcels 302 and 303.
I suppose the only finding, as a matter of evidence, is what Mr. Horsford used. The rest is really legal conclusions.
Yes. Yeah.
But the reference is to paragraph 7 and 8 of Mr. Horsford's witness statement, which you've shown us. Was his evidence in those paragraphs challenged?
Well, it was challenged because there was cross-examination as to whether or not you could get to the public road from west of the Glebe land, whether there was actually a road available to get there. And because on the map, certainly Mr. Horsford's road stopped at 193. And then on the map again, on the cadastral, there was evidence that no road, there was no road on the cadastral. There was, as I said, a dirt track. But the question is, was there a legal right to go across the dirt track? And that
No, my question was really, was his evidence that he had used that track as access, was that evidence of fact challenged? Or?
That evidence of fact was challenged because also there was cross-examination about how one could get from the lower road to parcel 281 because of the existence of a ravine and because of the disrepair also to that road.
And it's not in dispute, I assume, that one's got to have access via a car or vehicular access.
Oh, yes.
Rather than I mean, I'm just looking at the way the evidence of Mr. Horsford was put. He's talking about getting there by a path. He doesn't use the term dirt road. There's no question that he's saying, I can drive a car that route.
No, he doesn't say that at all. He doesn't say that at all.
And paragraph 19 doesn't tell us right of way via for vehicles.
Yes, and furthermore, if you look at the correspondence between Mr. Horsford and Mr. Croft, you start off with you were able to drive up the road. You're able to drive up the road. Then later on, it becomes you can only walk along the Upper Eastern Road, and then finally, by the time it gets to court, there's no access whatsoever. And so it's always been rather confusing as to what Mr. Horsford was saying. And so if we look at, I do hope the board now has a legible copy of page 55. But if we look at the way he puts it in page 55, that's a letter of the 19th of June 2005. I mean, I did email a legible copy. Does the board have that now?
Yes, we
Yes.
have that.
And if you looked at the letter,
2006?
2006, yes, 19th of June 2006.
Later version.
Sorry?
Later version. The legible copy, yeah.
Yes. Sorry, I've just lost. Yes, and so it's dated June the 19th, 2006, received 15th of November 2007, to all residents on Monks Hill Road and apparently the public at large.
And what is Monks Hill Road? Is it the whole of 281, but also running into the green part of the
Well,
road?
there was a dispute about that at trial because Mr. Croft says, as being a resident there, everyone knows the Monks Hill Road to be the upper eastern road and not the lower western road, whereas Mr. Horsford said they're both called the Monks Hill Road. How the postman delivers letters, I don't know. If they're both the Monks Hill Road, it must be a case of trial and error. But we would strongly say that that road has always been the Monks Hill Road, and indeed, when the judge went on
The red coloured area.
yes, yeah,
Not the green.
No, sorry, it's the Upper Eastern Road. Yes,
Yeah, the red.
the red. Yes,
Is the Monks Hill Road.
it is the Monks Hill
But
Road.
Mr. Horsford was maintaining that, in fact, it's the lower road as well.
As
The
well.
whole of this.
But
Okay.
when people go to Monks Hill, there's a fort at Monks Hill, they go via the Upper Eastern Road, and tourists go up that road to see the fort as well. But, dear resident, the Monks Hill Road is a private road owned solely and exclusively by myself, and any interference by you or any other person is a trespass that will not be disregarded. Your rights as it relates to Monks Hill Road is limited only to access to your property that forms part of the Monks Hill estate and is subject to the road conditions based on normal wear and tear and the weather. You cannot take upon yourself individually or as a group or to alter or otherwise interfere with the road, and the rest is about a complaint about the road. But this was hand-delivered, and it's not a dispute, hand-delivered to Mr. Croft on the 15th of November 2007. Then later on, when the parties fall out, Mr. Croft is told that he only has pedestrian access, and if he wants vehicular access, he has to pay. And then he's told he can't go at all, use the road at all. And it seems a rather odd letter to write if to deliver to Mr. Croft if he didn't have a right to use the road at all.
Well, except that you told us that Mr. Horsford's position was that the Monks Hill Road includes the green bit as well.
Yes, but except that Mr. Croft wasn't using the green bit, and there's no evidence of him using the lower western road. So it would seem rather an odd letter to write in relation to the lower western road when he's not in fact using it. Well, look, I've made certain submissions in my written case about the claim being from the outset a dishonest claim, my lord. And I say that because throughout, Mr. Horsford had denied transferring the land to Paul Van Beek. And it was an odd thing to do, but the Court of Appeal also found that it was transferred to, the land was, parcel 171 was transferred to Joanna Tobbit. And I say that's clearly wrong in the light of the judgment of Madam Justice Robertson, who came to the firm conclusion that Mr. Horsford did in fact transfer to Paul Van Beek. And I address the findings of Madam Justice Robertson.
But what was that not in the register?
Sorry?
Was the transfer to Mr. Van Beek not reflected in the register?
It was reflected in the register, yes.
So in what sense could it have been a fraud? It would have been a very strange fraud.
He said it was a forgery, didn't
he? He said his signature on the instrument of transfer was a forgery.
Right.
And then in the evidence, what was discovered was a fax from Mr. Horsford saying, yes, go along with the subdivision, you can subdivide, and also you can transfer, but only on condition that parcel 218 cannot use the lower western road and can only use the upper eastern road. But throughout his evidence in the court below, he insisted that he didn't transfer to Paul Van Beek, and it's rather odd. And as I said, he appealed against the decision, and the appeal was struck out.
As I understand it, you draw attention to this in the context of the easement of necessity,
yeah,
because you say that it would follow from that there must have been a right to use the upper road.
Yes.
But to the extent that you're seeking to open up a broader point based on dishonesty, a separate point,
yes,
easement of necessity, I'm not sure it's open to you to raise this dishonesty point on this appeal.
Well, my lord, I put it in this way. I say, insofar as the Court of Appeal paid attention to paragraphs 7 and 8, I would submit that credibility really is an issue there as to whether the Court of Appeal should have believed that, and indeed whether the board should believe what Mr. Horsford said at paragraph 7 and paragraph 8, because it's absolutely clear that so far as his evidence is concerned, it was tainted by the evidence that he gave in 0641 of 2012. And it just, I say his evidence is not credible. Because
are you saying that the Court of Appeal judgment should be set aside on the basis of dishonesty?
I'm saying that the Court of Appeal did not have the full facts before it. The Court of Appeal came to the conclusion, came to the finding of fact that Mr. Horsford had transferred, not just sold, but transferred to Joanna Tobbit. And that was one of their reasons for coming to the conclusion that in this case, he was entitled to use the lower road. It's one of the reasons they gave to say that Mr. Horsford succeeded.
Can you just show us what the passage you're referring to.
Yes, I'll get the judgment. So the judgment starts at page 315 of the electronic bundle, and it's the judgment of Madam Justice Henry.
Bear with me.
I do apologise, I did have this marked.
Is it paragraph 21?
Yes, it was Joanna Tobbit, who's owner of parcel 171, who caused the same to be subdivided into two parcels, one of which was purchased by Miss Croft. Joanna Tobbit is Miss Croft's predecessor in title, it's not part of the lands, but it goes on further as well. I will find the passage, not a problem.
So on the findings as they now stand, as a result of Mrs. Justice Robertson's decision, is this right, that the legal estate was agreed to be sold by Mr. Horsford to Miss Tobbit?
It was
agreed to be sold. There was the agreement, but it was not. There was no transfer of the legal title to the estate to 171 to Miss Tobbit. What happened is that while it was still legally, while legal title was still registered with Mr. Horsford, 171 was divided into 218 and 219.
Yes.
And
217 and 218, yes.
Is that right? Sorry, 217 and 218, forgive me. And then, is this right, the legal title was transferred by an instrument from Mr. Horsford, 217 to Mr. Van Beek. No, the whole...
217 and 218 to Mr. Van Beek.
But as separate parcels.
As separate parcels, yes. And then 218 is then transferred to the Bridges, and 217 is then transferred to Mr. Croft.
Yeah, thank you. Just got that right. Yeah.
But it's the...
Right.
But it was, the Court of Appeal did make, and I'll look for it and come back on that, but the Court of Appeal did say in terms that it was agreed that parcel 217 was transferred by Joanna Tobbit to Mr. Croft, and that is...
If the relevant time for the creation of any easement of necessity was in 1992, then the precise route by which the legal title to these two parcels ended up where they are would not really matter very much, would it?
Well, if it's 1992 alone, it wouldn't matter.
It wouldn't matter. If it's 2000, if it's in 2005,
yeah,
whatever it is, then of course it might matter.
Then it would matter. It would matter. Yes.
Might matter.
Yes.
Even though, of course, there never was, on no account was there a transfer from Mr. Horsford to Mr. Croft.
Yes, that's correct.
It either went, well, we now know it went via Mr. Van Beek.
Yes, yes.
But on Mr. Horsford's case, it went via Miss Tobbit.
The difficulty is that in 0641,
Sorry, which is it?
Mr. Horsford sought not only to have the title revert to parcel 171 in relation to Mr. Croft, but also sought to take it back from Mr. and Mrs. Bridge as well. And when he gave evidence in the lower court, my lords, he actually said that so far as Mr. and Mrs. Bridge were concerned, that they didn't use the Upper Eastern Road.
Yes, I was going to ask you actually that, I mean, it said that Mr. and Mrs. Bridge were only allowed to use the Upper Eastern Road.
Yes, yes.
Where do I find...
But in the trial...
No, but sorry, just before we get it, where do I find that? Is that...
It's recorded in the judgment of Madam Justice Robertson.
I see.
And also on the facts that he sent, which is also in the papers as well.
So it's in Mrs. Justice Robertson.
Yes, in her judgment, she records, she recites what is contained in the facts.
When you say in the facts, what do you mean?
There was a fact sent by Mr. Horsford in...
Facts? Oh, facts, sorry, yeah.
A facsimile transmission.
Yeah, it's sorry.
Sent by Mr. Horsford in August of 2009, which stated that Mr. and Mrs. Bridge could not use the road east of Bailey's Supermarket, but had to use the road from Cobb's Cross. Yes?
Yes. Yes.
And
okay.
Whereas in the trial itself, when he was asked about what they used, he
when you're referring to the trial, do you mean in our proceedings or before
the trial in our proceedings? Right. When he was asked about that, and I believe it's at 2:10. I'll just check my reference. Yes, at the top of page 210, where he said that Patricia Bridge does not use that road. They have an access that is not on that road. So that's at page, yes, that's at page 210, the top of page 210. So he was saying different things to the before Mr. Justice Cottle, and in fact, they could only use the Upper Eastern Road.
Just so that I've got it, can you...
Yes.
Others may have it, but the reference in Mrs. Justice Robertson's judgment to Mr. and Mrs. Bridge only...
Oh, that's in Madam Justice Robertson's judgment.
Yes. And where is that?
And that would be at...
If you just give me... Yes.
Yes, the paragraph number of the judgment.
I think there's a reference in paragraph 30 to this.
Yes, that's it. Yes, so she recites from the transcript, the party whom parcel 171 kindly make reference to on the agreement purchase, and then British must give an undertaking not to use the road, i.e. the Gordon Ground Road, entering east from Bailey's Supermarket, but rather the road from Cobb's Cross. And in the judge's findings of fact, he says...
Whose writing was this? Is said to have been?
It was put to Mr. Horsford that it was his writing.
His writing, right.
Yes, okay. And he denied ever seeing the document at all. He also denied that it was his fax number, even though on the relevant document, his fax number was shown at the bottom.
Yeah, okay.
Although I see that time is getting on, but so far as the difficulty with Mr. Croft accessing his property, I simply draw the board's attention to the report of Mr. Sandy Mayer, the civil engineer, and that can be found pages 417 to 421, and that's just to show that he cannot access the house, as it were, from the bottom road, and that was before the Court of Appeal on the application for a stay of the injunction.
Is there an additional problem with that road being blocked?
Yes, there have been problems with the road being blocked over the years, and first of all it was overgrown. Then the top of the road towards the bend was blocked by large boulders, so it was impossible to pass. And then there was also, during the hurricane season, the water washes the top of the road away completely. So, and because there's a ravine there, and the ravine floods.
But are those problems, if you like, going north as opposed to going south?
They would be going towards the north. The ravine is north of Mr. Croft's property.
Yes, what I'm saying to you, is there any difficulty? The case against you is that there's a perfectly acceptable dirt road going down from the lower Western Road through ultimately to the highway. I'm just asking whether any additional point you want to make about whether that route is impassable in any event, or is it only if you're going north on that lower Western Road?
If you're going north on that lower road, right, that would be the problem. And then the other problem, of course, is the slope that Mr.
Yeah, no, I appreciate that.
Yeah, yes. And I should point out also at page...
Just before we move away from the engineer's report, can you just tell us the date of it?
17th June 2020, I think.
Oh, yeah, thank you.
It was 2020, it was before the Court.
I have it, thank you.
By the way, the fax is at page... The fax that I referred to is page 412. And you'll see on the bottom of the page Mr. Horsford's fax number. So he receives the fax and then he sends a fax back. That's at page 412. But going back to the map, back to the report of Sandy Mayer, it's undated, but it was produced to the Court of Appeal in October 2020, so that the...
No, it's not undated, my lord's pointed out. It's dated the 17th of June 2020.
It was produced in 2020. It was exhibited to Mr. Croft's affidavit. Oh, it is... At page 417, the second paragraph, I was engaged by Mr. Croft to carry out a level service house in the property at Monks Hill Farmhouse. The work was done on Tuesday, the 16th of June 2020. So we know the report was completed sometime after that date. I'm looking at the time, but can I just address the court briefly on the question of hardship? The difficulty for Mr. Horsford is that the Court of Appeal granted an injunction, and if a permanent injunction were to remain, it would mean that he couldn't access his house. Physically, he cannot access his house. And it was for that reason at 412 that in 2020, the chief surveyor actually registered a right-of-way for him, as well as all of the occupiers along the Upper Eastern Road, and that's at page. That's at page 414.
That's been challenged.
That's a new challenge, yes.
There's an appeal pending.
No, it's not an appeal. There's a trial pending.
Trial pending.
There's a trial pending in relation to that, but that was also in relation to all of the properties on the along the Upper Eastern Road. And the odd thing is that although in 0641 Mr. Horsford challenged the right of parcel 218, they are not a part of these proceedings and haven't been sued, so he's left parcel 218 to use the Upper Road. The other point, I just want to go back to this.
Mr. and Mrs. Bridge have been left out of the...
Yes. But the other point I want to make about dishonesty is this. It is directly relevant to this case, because when Mr. Horsford gave his evidence, he said there was never a history of parcel 171 being accessed along the Upper Eastern Road. However, it's quite clear from the facts that parcel 218, which I would submit is part of the history of access, had the right to use the Upper Eastern Road. And parcel 218, of course, is a subdivision of parcel 171. And I'm looking at the time. Finally, my Lord, I made the point about the actual encroachment and section 17 of the Registered Land Act and section 18 of the Registered Land Act. That's contained in my written submission, so I think it's explained fully there, and I wouldn't really have much more to add about that, save that in the evidence, well, first of all, in the defence pleaded that section 17, and in the evidence, Mr. Croft in evidence gave evidence about having two other surveyors look at the encroachment, and they both got smaller measurements than Mr. Oliver Joseph. And the final point I want to make about the report of Oliver Joseph is this, is that the Eastern Caribbean CPR has a similar provision to section, to CPR 3510 of the English provision, so that the expert has to give declarations and so on and so forth. In the Eastern Caribbean rules, it is CPR 32.14. And one of the surprising things about the judgment of the Court of Appeal, and indeed the trial, is when one looks at the evidence of the brief statement of Oliver Joseph, the surveyor, there was no expert's declaration at all, either in the statement itself or either brought out when he gave evidence and cross-examined. And I would submit that little, if any, weight should be placed upon that, and that he also accepted that the boundaries had not been fixed. So the proper course was for the Registrar of Lands to consider the matter, and indeed they would have had the power under Section 18 to adjust the boundaries. I think I've gone at about a minute or so over, but
Well, you had a late start. So,
there's some
so you brought it in on time, Mr. Carroll. Thank you. Mr. Simon.
May it please you, my lords. Allow me first to draw your attention to the chronology, which is attached to my submissions at page 6 to 7 of the electronic bundle. I think for a proper appreciation of the matter, one really has to look at the historical development in terms of the parcels of land. Now, in October 22, 1992, the estate of William Horsford, of course, had parcel 161, and that was mutated to create parcel 171. And 171 was then transferred from the estate to Mr. Horsford. And that was done in 1993, June of 1993. In October of 2000, Mr. Horsford responds by fax to Richards & Co. in respect of an inquiry with the purchase of parcel 171 and states, "The access road is already in place. My undertaking is to have the road cleared of the overgrowth and made accessible. This will be done before December 15, 2000. In fact, Richards & Co. at that time acting for Mr. Van Beek.
So it's a small point and probably doesn't matter, but in fact, the agreed statement of facts and issues, paragraph 3, says that it's on the 22nd of October 1992 that Mr. Horsford, as sole administrator, conveyed parcel 171 to himself in his personal capacity.
Yes, but 293 is, well, you have the instrument of transfer, and then that is registered. So what we have here is the note when it actually was registered at the land registry.
All right, okay.
Your Lordship was looking at what paragraph?
Sorry, so can we, so the conveyance in paragraph 3 of the agreed statement of facts and issues, that is not correct. It's not conveyed on the 22nd of October, because the conveyance is presumably the date of the registration.
Not necessarily, because the conveyance happens to be an instrument of transfer, and that is then presented to the registrar.
Right.
For transfer of the land.
Okay.
Within the record of the land registry.
So, sorry, are you saying 7th of June 1993 is the date that that transfer
took effect?
Was recorded in the registry?
In the registry, would take effect in the registry. So that the land register would reflect that date. And you do have times when the transfers are delayed in terms of registration. In fact, we have that in this particular matter, and I will come to that later. Now, the sale agreement, which your Lordships will find on page 108, which was between Joanna Tobit and the respondent, in his personal capacity, indicated quite clearly that the vendor shall, prior to the completion date, clear and make usable by vehicles the lower road that provides access to the property, and further clearly mark out and identify for the benefit of the purchaser all of the boundary stakes relevant to the property. So the agreement was very clear in respect of the access road. which of course had been inquired into since 2000 in respect of the sale of that land. Now when we look at the survey map, which is at page 614 of the record, parcel 171 was the parent parcel of 218 and the 217, which was subsequently subdivided into 291 and 292. So there we have parcel 171, and it is very clear on the map that on the west is the Lower Western Road, and on the east is the Upper Eastern Road. And it is the Lower Western Road that access was given to that parcel. Now we speak of road, but I just want to make it abundantly clear that in that development, it was not a public road, therefore it was not concreted. It was basically a pathway, but sufficiently wide enough for vehicles to pass. I have actually driven up on that road.
Where are we talking about? The Green Road or beyond the Green Road?
Unfortunately, I don't have the color. Does your lordship
Sorry, the Lower Western.
The Lower Western Road? Yes. So that is where the access was given to parcel 171.
Yes, you're saying the Lower Western Road, which on our map is green, is a dirt track that is passable by vehicles.
Very much so.
Yeah.
And in fact, it comes down, your lordships will look, parcel 152, 193. From 193, the road goes further west and then comes down along 302, 303, 17, and goes way down to parcel 18. So the road is actually there. And proof of that, we have supplied to the court, again attached to the respondent's submissions at parcel 630.
Can I just ask, the Upper Eastern Road, is that of a different character, physical character, than the Lower Western Road?
No, it's not.
So basically the whole of the Upper Eastern Road and the Lower Western Road are this dirt track where vehicles can pass. Okay.
And what is also important to bear in mind is that both roads are on lands which belong to the estate. They're estate lands.
So you're saying, by reference to your plan on 630, are you submitting that once the road leaves, the dirt track leaves 193 and enters the side of 302, 303, 17, it's in exactly the same condition?
It is.
Well, why on the plan 630 is it marked right of way and then road? So if we look at the left-hand side, I assume that's what you're referring to.
Oh, yes, yes, Miller. What that is really, it's a map of the subdivisions of 229 to 224. That basically is what it is.
Yeah.
But they have enlarged it there, and I just utilize that to indicate that the road certainly exists. And you will see it's marked road.
Well, it's partly marked road, but it's also partly marked right-of-way. Why the two? So top left,
Oh yes,
it says right-of-way.
It says right-of-way, top left.
Yeah, and then it says road, and then the bottom right says right-of-way.
And then it says road. I'm not too sure why that was done in that manner. But if you will look at where it says right-of-way, you will see it's next to parcel 219.
Yeah.
And when you look at page 614 of the map, you will see where 219 exists. So it is there.
Well, we've got no. I mean, you're saying that's a road, but it's put against you. It isn't. That it's actually it's a pathway.
Well, it's motorable. Let me put it this way. The whole road is motorable, although even the right-of-way itself is motorable. And what is important to bear in mind is that all of these lands were once belonging to the estate. And in subdividing, which is what the personal representatives of the estate have been doing, subdividing and selling, they have created that road. I think it's being called a right-of-way, but it's really a road. Either way, it gives access to parcel one from the highway up to parcel 171.
Can I ask, what is the document at page 630, and what is its date? It seems to be dated, if one looks at the bottom right-hand corner, the signature, November 2006.
Yes, very please, my lord. It's a recent document.
Right.
So it really is not.
When was the right-of-way that's shown here created?
It has always been, and that's the point which I wish to make, because if your lordship looks at page 614, you will notice there is this how should I put it? There is a way you can see which moves from 193, 260, 219, and it ends at 219, a little sliver. And that actually corresponds.
But it doesn't show the road down.
No, it does not.
So
yes, it does not.
Nor does it show a right-of-way down.
No, it does not at all.
So my question was, when was the right-of-way shown on page 630 created?
From my understanding, that this has always been there, and it is on that basis that the access was given. And there was no issue in respect of that.
All right. Do we get any help with the evidential status of page 630 other than the dates that it itself bears?
No, there is nothing, no evidential, because actually I got that subsequent to my preparation.
Right, because this document 630 is headed creation of right-of-way. It rather suggests that the right-of-way is being created in 2006, and this is the surveyor's document showing the creation of a right-of-way.
But it's a creation of a right-of-way in respect of 224, 225, which is on the...
Yes, but only being created in 2006.
Yes, but not the road which I'm actually indicating to your lordship. The right-of-way is being created on the right, which would be the eastern section of those plots.
Right, but you see the heading on page 630?
Yes, I'm seeing it.
It says creation of ROW, which I'm rather assuming means right-of-way.
Yes, of over parcels 224, 225.
So this looks like a surveyor's document drawn up to create, i.e. something that wasn't there before, rights-of-way in relation to 224 and so on.
Yes, madam.
As at November 2006.
That is indeed so. But what your lordship will also recognise is that
I'm so sorry to interrupt. That would tend to indicate that there was not a right-of-way shown here before 2006.
But the point I'm making is that the right-of-way which is being created here is on the right or eastern side of parcels 224, 225. So it's not relevant to us, because what we are looking at is the road which is on the western side.
No, but there's a
right-of-way on the western side.
But there's a right-of-way on the western side. Do you see at the top? Then there's a road, and then there's a right-of-way at the bottom southern side, which you need in order to access the road and the other right-of-way.
Yes. But if your lordship looks at the lower, how should I put it? The lower definition of the plots.
Yes.
You will see that this is the right-of-way is right here. That is where they have actually numbered the various parcels, and that is the right-of-way that was being created.
So I'm sorry, I'm lost now. Which is the right-of-way that's being
You mean
created?
the blown-up part to the right?
The blown-up part to the right.
Yeah.
That was the right-of-way that is being created. To the right.
Oh, I see. Running up the right-hand side.
Yes. Running up the right-hand side to parcel 224.
And then going, I see.
Going left and up. That is what was being created.
One can
And
see
then it stops.
ROW.
Sorry.
You can see ROW in manuscript. It looks as if it's in manuscript on the left-hand side.
To show revised plan, to show ROW. Right. But
So on the left, where you have the road and the right-of-way, that was already existing. So that was not being created at that stage. Or at that date.
let's see.
And what is the document at page 630? Does this get appended to some transfer instrument which is then registered?
It would be appended to the register of 224, 225, 226, 227, 228.
All right. And what do you... So if one's looking then at the left-hand side of the blown up...
yes, which is next to parcel 17.
One sees right-of-way at the top, but not right-of-way along the road. Is that indicative of the fact that there is not, in fact, or was not, a right-of-way along the road, what is marked as the road?
No, it is not. I suspect it is just how the pathway was being looked at. This being the road and this being a right-of-way. But it's a continuous road.
Yes, but
You see, it's not. Unfortunately, when I went to the land registry, I was not the land registry, the survey department, we were not able to get a full picture.
Right. And
Which would indicate that.
last question from me just on this. Where it says right-of-way written out fully rather than the manuscript ROW, do we know in favour of whom that right-of-way exists? Or in favour of what land that right-of-way exists?
But I would want to think that it exists in respect of all the parcels of land next to it, the ones that adjoin it. Because that would be the purpose of the right-of-way.
So that's just for the ones what's shown on this plan?
On this plan, yes, mate, please, Miller.
So not a right-of-way for parcels further up than this plan?
No. For parcels further up, I'm suggesting, respectfully, that it is the road on the left, next to parcel 17, and going up that right-of-way, and it will take you right up to parcel 219, 260, and 193. And then there is this curve, and you find yourself at 171.
Right.
well, but who owns the road?
The road is on the property of the estate.
It is on the property
Of the estate. All of that was estate property. In fact, this is what I want to indicate, that in respect of those various subdivisions, this was previously estate lands.
So the Western Road and the way that you have indicated, all the way down to where it joins the public highway, is land which is owned by the estate.
Was owned by the estate. Was owned by the estate.
Was until when?
Well, the subdivisions began well, I don't have a date when the subdivisions began, but in October 19, prior to October 1992, they have been subdividing and selling lands. And in October 1992, that is when Parcel 171 was created, and the respondent obtained that parcel of land in his own personal capacity.
But how did he obtain, do you say he thereby obtained an easement, a right-of-way down this road?
He would have obtained a transfer of the land.
Yes.
Yes.
But did that carry with it a right-of-way down what is marked as the road? Or?
It would have carried that because that road was on its boundary. That road, that lower western road, you will notice.
The green.
The green.
No, I'm talking about further down. You've been showing us this plan.
Page 630.
At page 630. What right-of-way would Mr. Horsfield personally have over that road?
In light of the fact that that road was an estate land, it would have been a road which would have been traversed and utilized by all of the parcels, the occupants of those various parcels which had been subdivided by the estate. So it was basically to give access to those various subdivisions.
But when I asked you a similar question, I thought that you told me that it gave a right of access up to, but no further than, plot 260.
No, I indicated on that map, it's up to plot 260. In fact, when you look right up to the top, I have actually numbered them 219, 220, and 221, which correspond with the survey map on page 614,
yes,
which gives you the whole picture.
Right, but it's still, as I understand your answer to me and as you're now describing it, it's a right-of-way for the benefit of the plots of land shown on page 630, which on page 614 extends from 260 in the north.
In fact, it extends from 239 from the north and coming right down.
260 in the north down to 228 and 229 in the south.
In the south.
And I just want to be clear that you're saying that the right-of-way that's described on page 630 is only a right-of-way for the plots of land which are shown on page 630.
No, I'm not saying that, brother.
All right, what are you?
I am saying that those plots of land which are shown on page 630 also use that road. And that road is what gives access down to parcel 228 and parcel 18, which will then take you up down to the public road by Bailey's Supermarket. So I'm just indicating that what we can do is we can use that on page 630, supplant it on page 614, and you will see that the road actually continues. So it's a continuous roadway.
But do any of the properties surrounded by the eastern and western roads enjoy any right to use this access to the highway?
Yes, they do. That's the point I want to make.
Well, on what basis?
If we look at parcel, we look at the transfer of parcel 171 to Mr. Van Beek, it is made very clear that this is your access road. that transfer, or sorry, the agreement is on page 108.
This is the Tobbit agreement, I thought, isn't it?
Yes, it is.
So this is going back
page 110. The provision is there. Paragraph 7.
This is the Tobit agreement, as my lord points out.
The vendor shall, prior to the completion date, clear and make usable by vehicles the lower road that provides access to the property, and further clearly mark out and identify for the benefit of the purchaser all of the boundary stakes relevant to the property.
Yes, but that doesn't say that there's a right of way running down the side
Yes, no,
of
it doesn't.
260.
It doesn't.
And just to complete my point, so you can deal with it, that could be a reference to getting access from the lower road, but where one has got to that point of access by driving over the upper road and round the top of plot 239.
No, I am respectful.
So clause 7 is not saying, and your only right of access to the property is from the lower road. It's just saying, and please make sure that we do have access from the lower road.
Yes, unfortunately, it does not go as far as your lordship has indicated.
And that would be consistent with also having access from the upper road. It could just be to make it more convenient to have access from the lower road as well.
Except that what we are dealing with respect to Mr. Croft, is that he is not indicating that he has an access to the lower western road. He is indicating that his access would be on the upper eastern road.
Seems to me we've got a difficulty because there's a fundamental conflict in the evidence that you're suggesting, or rather the lack of evidence, because you're saying that the lower western road effectively doesn't stop at 193, it carries right the way down to the main road, down the route you've suggested. The counter-argument is that there's no vehicular right-of-way throughout there. There may be pathway and a right-of-way in that sense, but you can't get a vehicle all the way through, and effectively the lower western road stops at 193. Now, where's the evidence that is going to help us resolve that problem?
Well, may I draw the court's attention to the judgment of Mr. Justice Cottle, which was the first instance judgment, paragraph, and there he has indicated that's at page 547. And look at paragraph 10, 549. In fact, we started paragraph 9. The facts of the matter are not in dispute. The claimant owns parcel 281. The first defendant uses parcel 281 as his means of accessing his home. The claimant does not consent to this. And the claimant there would be the respondent. On the face of the cadastral survey maps, the first defendant's land, as the appellant's land, is bounded by two roads, and it appears that he can access his property by means of the lower or western road. Paragraph 10, the court visited the locus in quo. Although we do not have particular evidence which indicates that the road can be traveled by vehicles, the court has visited it And that's how they visited the road. They traveled on that road to visit the locus in quo. And he goes on, it was at once patent that the access via the Western Road was only apparent but far from real. The topography rendered it extremely difficult to build a driveway from the road onto the first defendant's property. So the lower court has accepted that there is access from that road.
Well, there are, but when the judge refers to the cadastral survey maps, what precisely is he referring to? Which map or maps is he referring to?
The cadastral survey maps would be, one of them would clearly be page 6, what is on page 614. Because these basically are the survey maps which would be at the land registry. Unfortunately, these are not updated all of the time, or.
But is that what I mean is that what the judge is referring to?
Yes, may it please the court.
Yes.
That is that rule.
Okay.
Well, that might be a convenient moment at which to adjourn. We'll resume this assignment at 2 o'clock, please. Thank you very much.